See, let's take up the very first topic, which is your Uniform Civil Code. So, Uniform Civil Code, as we have discussed, has the Uttarakhand government has passed the Uniform Civil Code bill. Okay. Now, you must know this is the first state in India in the post-independence era that has passed the Uniform Civil Code. Only Goa, during the time of Portuguese only, they had Uniform Civil Code. So, but it is pre-independence. And following this move of Uttarakhand government, even Maharashtra government has taken some initial steps with respect to UCC. So what is the aim of Uniform Civil Code? What do you mean when we are talking about Uniform Civil Code? See, India is a secular country and it is a very diverse country. We have people belonging to each and every religion in the world. Okay. So catering to this diversity, we have different civil code. So we have Hindu Marriage Act and then we have Muslim Sharia's Act. So these are all the kind of acts which are regulating the civil matters. Civil matter includes your related to matters related to marriage, divorce cases, child, and all these matters are related and come under the umbrella of civil code. और अभी के टाइम पे because India is a very diverse country, they are regulated by their religious acts. There is no one code which is applicable to all the religion across the country. Okay, so UCC will create a uniform set of laws to replace the distinct personal laws of every religion about subjects such as marriage, divorce, adoption, inheritance of property. Okay, तो यूनिफॉर्म सिविल कोड जितने भी सारे एक्ट हैं उस एरिया में उसको रिपील करेगा और एक कोड है जो अक्रॉस ऑल द रिलीजन अप्लाई होगा. सो इट एम्स टू ब्रिंग इन यूनिफॉर्मिटी व्हेन इट कम्स टू सिविल लॉज इन इंडिया. ओके, however, when it comes to constitution, our constitution, that we found the reference to the Uniform Civil Code under DPSP, Article 44. DPSP, as you all know, are directive principles of state policy. Okay, so directive principle simply means these are the directions given to the government so that they can take steps in that direction, but they are not enforceable. That means you cannot take it, and they are not enforceable as well as non-justiciable. That means government is not bound to take action on it, and you cannot take this matter to the judiciary and ask the judiciary to force the government to implement such laws. They are sheer directions. Okay, डायरेक्शंस है ना, रूल नहीं है ना जो इम्प्लीमेंट होना मैंडेटरी है, डायरेक्शन है. दीज आर द एस्पिरेशंस. जब कॉन्स्टिट्यूशन फ्रेम भी किया गया था, देयर वर सर्टेन फंडामेंटल राइट्स एंड देयर वर सर्टेन डीपीएसपीज. डीपीएसपी वाज, this is the vision if you talk about future of India. Okay, this is where you see India moving, and why they were kept separate from the fundamental rights was because considering the current diversity at that time, contemporary diversity, then the financial restraint and the kind of communal clash that was going on. So accordingly, there were many things like equal wage, equality, and all these with respect to work and judicial services. They were kept under the bracket of DPSP. Okay, this is what we envision, and fundamental rights were the bare minimum things that if an individual is staying in an independent India, these are the necessity. Without these fundamental rights, we cannot move. But DPSPs were directions for the future of India. However, so far, government has not taken any concrete step in application of Uniform Civil Code, but Uttarakhand government has taken now this step to frame the Uniform Civil Code. So first of all, let's see what were the constitutional debates. Like we have seen कि हमने generally DPSPs क्यों बनाए थे, but let us now discuss कि UCC को, Uniform Civil Code को DPSP में क्यों रखा गया, फंडामेंटल राइट्स में या किसी और प्रोविजन में जो एनफोर्सिबल थी वहां पे क्यों नहीं रखा? Let's see the constitutional debates around UCC. So there were two type of arguments. One which were against putting them in DPSPs, and other was in favor of UCC कि UCC होना क्यों चाहिए, और दूसरी थी कि क्यों नहीं we should make it enforceable. Okay, तो जो लोग बोल रहे थे कि why it should not be made enforceable, because अगर हम UCC लाते हैं it will dilute the rights of religious minorities in India and destroy the diversity. As we have discussed, India is a diverse country and we do have religious minorities. And what are those religious minorities? So this is a question. There are 6 religious minorities in India. You have to find out, because we have discussed about this many times when we were discussing about minority issue, Aligarh Muslim University. If you have been following, comment in the comment section like which are the 6 religious minority groups in India. So it was the opinion of the people that if you will implement UCC, it will dilute the minority voice and it will hamper the diversity of India. Okay. Then there was this person, Naziruddin Ahmed, who was a part of this committee member. He said that it is against Article 25 of the Constitution, which guarantee fundamental right to freedom of religion subject to reasonable restrictions such as public order, morality and health. So as we all know and we have discussed multiple times, Article 25 it allows freedom of religion, okay, to every individual. Now that person mentioned that if you will impose UCC, that means they are bound to follow the law of the land but not the religion. So because religion also says some talk about the matter related to civil their personal laws, so that is why it will go against the freedom of religion. Now another thing they said, that if you actually want to implement UCC, you have to take the consent of the people, you have to take the consent of the minority specifically. Okay, so you have to take the consent of the concerned communities, you have to, because अगर सबके ऊपर same law होगा तो everybody should be ready to follow that law as well. Otherwise what's the point? Okay, if it is causing a dissent among the people, dissatisfaction among the people, so अगर आपको लाना भी है तो the society should be agree, because religious sentiments are very touchy area, so people generally don't want to alter those, and this we also witnessed during the removal of triple talaq as well, and we have also seen this during the matter of Sabrimala issue as well. So there are always two groups, who are against and who are in favor. So these were the argument put forward by the people who were saying the UCC should not be made mandatory. And then there was this other group which was in favor of bringing in UCC. So K.M. Munshi, he said that UCC would not defeat the principle of freedom of religion, since the state is empowered to make laws related to religious practices if they were intended for social reform. So he said that it will defeat the purpose of Article 25. Mr. K.M. Munshi said, no, it will not defeat the purpose of Article 25. Instead, since India is an active secular country, it's not a passive secular country, so state is empowered to make laws which will be responsible for improvement of social in bringing in social reforms. Okay, so this is something that we can do for the betterment. If you are bringing in UCC for the betterment, then you should bring it. Now, what are the benefits if you bring in UCC? The benefits are, it will promote equality for women, since personal law often prevent the elimination of discriminatory practice against women. So if you have been seeing the personal laws, they generally tend to be in favor of male and less in favor of women. So if you bring UCC, it will give equal voice to men and women in matters related to the civil laws related to marriage, divorce, etc. So this is where it says that UCC will benefit women. Okay. So when you talk about Dr. B.R. Ambedkar, what he said was, although UCC is desirable, it should remain purely voluntary in the initial stages. Okay, considering the communal clash in India at that time, considering the diversity and considering the naive nature of the country. Now he said provision was merely recommendatory. It should be upon the citizen. It should not be imposed upon all the citizens. Okay, we can keep it recommendatory that if you want to follow, you follow, but हमें impose नहीं करना चाहिए initial stage में because the country is not ready. See, किसी भी state के अंदर, किसी भी country के अंदर social reforms तभी value रखते हैं if the people who are living there are ready to take it. Say for example, let's take the example of British India. What happened during the British India? During British India, the British tried to reform the socio-religious laws in India, cultures in India. After, like, if you see Raja Ram Mohan Rai, he was there for women empowerment, and then on his convincing and the revolt that he took, the path that he took, his convincing strategies, he convinced William Bentinck to pass law banning the sati, which was a very good social reform, है ना? And there were many such social reform like property inheritance के related. There were good laws which were brought in. However, since it was not inclined with the ideology of people at that time, it was one of the major reasons of 1858 revolt as well. So people went against the British. Okay. So what does it show? That social reforms are only successful only when society is ready to accept this. Say for example, as we discussed about the British laws, right? Now let's see Supreme Court. What does Supreme Court has so far said with respect to UCC? So in 1985, the Shah Banu Begum case. So this is an important case to remember. It is a matter of regret that Article 44 has remained a dead letter and called for its implementation. ठीक है? So Supreme Court has said, because we have seen triple talaq and there were many sort of such provisions which were against the women rights. So Supreme Court said that it is saddening for them that it is still dead. The provision of Article 44 has not been implemented so far. So it was in favor and it said that it should be implemented. But Supreme Court is a judiciary body. It is in the hands of legislature and executive to basically frame policies regarding UCC. Okay. So subsequent demand were also raised in these cases. Sarla Muddal versus Union of India case and John Wallambden versus Union of India 2003. So you see the diversity of cultures. Okay. Hindu, Muslim, and then you have Christians. So this is the diversity from where the demand was coming. Okay, but it is not necessary that all the people of these cultures are demanding this. No, but there are certain people who approach the Supreme Court from different cultures, right? Then again, 6 petitions were filed between 21-22. That means in last years, seeking uniformity in divorce, maintenance, and alimony laws on the ground that discriminate against women. Thereby, they also violate Article 14, which is your right to equality, and Article 15, right against discrimination based on religion and gender. So, however, Supreme Court, in a bench headed by Chief Justice of India, D.Y. Chandrachud, he dismissed these petitions by saying that the issue falls within the exclusive domain of the Parliament. Okay. Now, these are your fundamental rights. Article 14 and Article 15. And if you talk about Sabarimala issue as well, the verdict was also in favor of the women because it was violating Article 14, right to equality. Now here they also filed petitions saying that women are often discriminated in these laws if you talk about religious laws, personal laws. So they demanded that there should be uniformity in the laws. However, Supreme Court held, as we have discussed, the matter with respect to formation of law fall within the domain of legislature, the Parliament. So that is why there is nothing much then Supreme Court can do. Okay. Then in January 23 again, there was a petition filed by members who were against the UCC committee formation for the UCC by the Uttarakhand government. and because they framed the committee to implement UCC, and the Supreme Court again said that it falls in the domain of the state legislature. If they want to frame laws regarding to the marriages and everything, that they are free to do that. It's up to their will. Okay, so there is nothing much that Supreme Court can do. Supreme Court, however, can do if there are certain provisions in the law which are not constitutional, which goes against the constitutional mandate, then obviously on those domains Supreme Court can give its decision if that is taken to the Supreme Court, right? However, if mere for them to make law on a subject that fall within their domain, it's constitutional, then why will Supreme Court intervene there? So that is perfectly constitutional for them to frame laws on the matters related to marriage, divorce and everything, because they fall under the concurrent list entry 5. So under Article 162, it is the state government who can frame laws related to these matters. So that is why, however, if you find today, as we'll be discussing, certain laws which are not constitutional, certain provision of the law which is not constitutional, you are in all your rights to take that particular provision to court and ask them to whether comment if it is constitutional or it should stay, and if it is not constitutional it should not stay. Okay, now that falls within the domain of judiciary to judge the constitutionality of the law or not. Okay, now that is something which fall within the domain of judiciary, but mere formation of law doesn't fall, that falls under the domain of legislature. So if you talk about law commissions, give me a second. If you talk about law commissions, so in the 21st law commission, see these what we are discussing with respect to Supreme Court provision, the debate of the Constitutional Assembly, then these law commissions, they will give you very important points and you can use them to substantiate your arguments whether UCC should be implemented, should not be implemented. So make a note of these points, and you can also download the PDF from the Telegram channel, or I'll be giving the link for the channel in the description box below. So from there you can take. Other than that, let's talk about law commissions. See, law commissions का क्या opinion था? It was in 2018 August. That 21st law commission headed by the former Supreme Court judge Balbir Singh Chauhan submitted consultation paper, and it said that unified nation did not necessarily need uniformity, adding secularism could not contradict the popularity prevent. Okay, so what does it say? Secularism cannot contradict popularity. So this particular, however, he recommended that discriminatory practices and stereotype within existing personal law should be amended. Although it said that there is no need of uniform civil code at present, we do not need it. Okay. However, if there are any practices which are discriminatory in nature, which are stereotypic provisions, you can eliminate them. They need to be amended, but it is not desirable at this point of moment that you implement UCC. Okay, this was the opinion of Law Commission in 2018. Coming to 22nd Law Commission, which was in 2023, the opinion changed. The 22nd Law Commission, headed by Justice Rituraj Avasthi, issued a notification and said that they should implement UCC. Okay. Now, let's move to the next topic, which is Sri Lanka fishermen issues. I hope UCC for now for you is clear, but I think we missed the discussion of Uttarakhand bill. So Uttarakhand basically has taken very positive steps when you talk about removal of some practices which were discriminatory from various laws, like triple talaq, and these sort of methods were eliminated. But there was one bone of contention which was highlighted so far, that the Uttarakhand UCC tried to formalize the live-in relationship, and the couples who are trying to move into live-in relationship will now have to register before they move in. So although the good part of it, they have legitimized children born out of live-in relationship, and in the times when you have deserted the other person, you have to pay, as alimony is paid during divorce. The money has to be paid. However, there are two problems with this. It defeats the entire purpose of live-in relationship, and it eventually give it equal the formalization put it in equal place with marriage. Second thing is, it is an unnecessary intrusion into the privacy. So it goes against the right to privacy under Article 21. So we might see in future that these provisions will be taken to the Supreme Court, and we might see a judgment on this. So if at all this happen, we will look forward to it, and we'll discuss the pros and cons and the discussion with respect to constitutionality of these provisions if at all the matter is taken to the Supreme Court, which is likelihood.